Tommy Broughan.
Thanks, Caherlock, and I'm delighted to have the opportunity to contribute briefly on this very important data protection bill before us, and a very lengthy, of course, and comprehensive bill. And at the outset, I'd also like to commend Senator Alice Mary Higgins and other Senate colleagues for the work they did in trying to improve the bill, which started in Éireann. The bill, of course, is to give effect to the General Data Protection Regulation, the GDPR Regulation EU 2016-679, and transpose the 2016 directive into law. And while we've known, Minister, that the updated EU-wide data protection regulations were in the works for the past 2 years, the actual transposition into Irish law is coming at a very opportune time, with Mark Zuckerberg recently appearing for questioning before the US Congress and Facebook executives appearing before our own Oireachtas Committee on Communications, Climate Action and Environment this week. It's right that we are talking about greatly improving data protection for, and I quote, data subjects, or for obviously for all of our citizens, and the value of our data, of course, to large multinationals. The recent Facebook scandal, where approximately 87 million Facebook users had their data harvested, unbeknownst to them, has thrown digital data into the spotlight again. So how Cambridge Analytica was allowed to secretly harvest data from the friends of people who download the This Is Your Digital Life app is shocking, as are allegations that harvested data has been sold and used to manipulate the outcome of election results, such as that of President Trump and the passing of Brexit. Recent revelation and allegations around serious data breaches in independent news and media is also very worrying, Minister. I'd like to echo the calls of Deputy Micheál Martin and Deputy Mary Lou MacDonald for legislation in this area, and greater support for the Office of the Director of Corporate Enforcement also. But it beggars belief to think that 19 individuals, including very distinguished journalists such as Brendan O'Connor and Sam Smith, were targeted to allegedly have their emails and records scraped and taken to the UK and then interrogated by unknown third parties. In April 2017, the House, of course, was presented with a very important report by Mr Justice John L. Murray on the review of the law on the retention of and access to communications data. Mr Murray's report highlights the importance to our democracy and society of the confidentiality of journalistic sources, and called for legislation to govern access to retained communications data, including the data of journalists. And just be asking the Minister, perhaps in his reply, to indicate where within this very detailed bill, and I've studied it like my colleague Deputy Pringle very carefully, where exactly is that issue addressed. The report concludes that such legislation should be consonant with the system of communications data retention and disclosure of safeguards laid down by the European Court of Justice in the Telly 2 case. That system should include standards and procedures to be observed by service providers to ensure effective protection and security of retained data against the risk of abuse or unlawful access to or use of the data. So will the Minister confirm that all the key recommendations of Mr Murray's report on data retention, and particularly on the protection of journalists, that will be implemented in the bill before us, or will we have to return to that at amendment stage? I note that a joint class action under the US Stored Communications Act has been launched against Facebook, Cambridge Analytica, SCL Group Limited and Global Science Research Limited by lawyers in the UK and the US. And I think US legislation sets out a minimum $1,000 penalty, meaning damages could be in excess of $87 million based on the figure that Mark Zuckerberg gave to Congress. But it does seem that the majority of the people affected by Cambridge Analytica data breach are in the US, over 70 million. There are over 1 million in the UK, others in Australia, India and Canada, but up to 45,000 possibly affected in Ireland, those of us who have a page on Facebook. And of course, the Joint Oireachtas Committee in its pre-legislative scrutiny of the bill recommended that a provision for class actions should be explicitly prescribed in this legislation, and it's not in it. However, the final bill, as I said, doesn't include that. Our always informative Bills Digest and our library mentions, of course, that the Sinn Féin Private Members Bill on Class Actions, Multi-Party Action Bill 2017, that was referred to the Select Committee on Justice and Equality, and it will undergo pre-legislative scrutiny. But the importance of having such an option for data subjects, since so many people can be affected in Ireland, has been clearly evidenced in this matter, and I hope that the Multi-Party Action Bill will be prioritised with the urgency it requires and deserves, Minister. We had the Law Commission report from, I think, 2005 on that matter, and they set out a bill. And I also note, of course, that Deputy Penrose and the Labour Party produced a similar class action bill on mass harm. I also supported the important Online Advertising and Social Media Transparency Bill 2017, brought forward by your colleague, Caherlock, Deputy James Lawless, which passed second stage. Deputy Lawless bill, of course, requires online political advertising to fulfil transparency standards and outlaws the use of bots to cause misleading online presences directed towards political ends of the type referred to by my colleague Deputy Pringle. I agree, of course, with the principles of the bill to give effect to the GDPR, the establishment of the Data Protection Commission with up to 3 commissioners, and a significant administrative fines for private companies. And Section 8 of Part 1, of course, provides for certain parts of the 1988 Data Protection Bill relating to defence and national security to remain governed by our national legislation. That's an area also that might be explored again in amendments. Part 2 of the bill provides for the changes to the Data Protection Commission, and a welcome confirmation of preparation has already been underway to get ready for an increased workload, with the increase of staff resources to around 120, up from only 30 in 2013, and with a budget, I believe, Minister, of 11.7 million in 2018. But I note, however, there are no plans to appoint additional commissioners. I think perhaps like other agencies we've been familiar with, perhaps we should fulfil and fill the 3 commissioner posts. I note some of the comments made by the Minister in the opening speech yesterday, Minister for Justice, including the need for further assistance to SMEs and also the risk-based approach to be taken to data protection. It certainly makes sense that each controller and processor of data will analyse their collection, collation and use of data, assess the risks associated with being responsible for other people's data, and then put the appropriate measures in place to comply with the new and improved data protection standards. Section 29, of course, of the bill confirms the definition of a child to mean anyone under the age of 18 years. Section 31 though specifies the digital age of consent to be 13 years of age, Minister. Article 8 of the GDPR allows Member States to set the digital age themselves as long as it is between 13 years and 16 years. And of course in the Seanad and in the media this provision came in for a lot of debate and discussion. Personally, I feel that a digital age of 16 years would have been more appropriate. I note that leading children's groups, however, such as the Children's Rights Alliance and the Irish Society for the Prevention of Cruelty to Children, recommended that the digital age of consent be set in line with most of the rest of Europe at 13 years. However, given the amount of data which we know has been unscrupulously harvested by social media companies, 13 seems very young for these companies to start taking, manipulating and using their data without consultation with their parents and guardians. So I welcome the amendment to Section 30 for the review of the digital age of consent within 3 years, which the Minister agreed to in the Seanad. And of course Section 32 provides for the right to be forgotten for children as per Article 17 of the GDPR, which is also very important. But the key aspect of this debate, Cathaoirleach, is the responsibility of social media platforms. We saw Mark Zuckerberg argue that Facebook and many of its apps are publishers and not platforms. And we know, debates that are taking place in the United States around that, particularly the decision of Congress, where there was huge lobbying by the massive IT industry from California around 2015. But surely Facebook, Twitter, YouTube, Instagram, Snapchat and all the other platforms we're familiar with are also responsible for the vitriol which is often directed at people. We've seen the publisher apps being used by terrorists on these platforms, showing videos of executions. We've seen hate speech broadcast and normalised. We've seen online bullying lead to young people dying by suicide. Why should faceless trolls or sometimes school peers be allowed to target and bully people in this way? We can see it currently with the referendum campaign and those who've had to sign up to Repeal Shield to protect themselves from online attack. The Repeal Shield is an online tool which blocks hateful, abusive and insulting accounts for people contributing to the debate. But why should Twitter, Facebook, Google, YouTube, Instagram, etc. not be responsible for the contents that's posted? I think this argument about just being a publisher is a vacuous argument. As well as being responsible for the data that's held on the users of those and other sites, those organisations like Facebook should also be responsible, I believe, for abuse of content. I welcome, of course, this week's news that Ireland will be included in the new advertising transparency measure, which Facebook says it's piloting, which is due to begin on April 25th. And that's certainly important, and given that so many of these companies have their headquarters not very far from away from this Dáil. The GDPR, of course, as my colleague noted, will profoundly affect our own political work and the work of the Oireachtas. We're contacted, of course, day in and day out, indeed 7/24 at times, by constituents and civil society bodies and groups with personal information and needs, and it's necessary to hold that information while we're making representation and trying to achieve outcomes for constituents who turn to us in desperation. I've always believed, however, in keeping all my constituents informed of my own work in the House and the constituency, and for that reason I've always published a quarterly newsletter throughout my time in this House. But I note that Section Sections 52 and 53 of the bill will exempt the right to object to direct mailing when it's for electoral purposes. Senator Alice Mary Higgins has, however, raised concerns that there is nothing in this bill, as it stands, to prevent political parties engaging the services of a company like Cambridge Analytica. And perhaps that's something the Minister for Justice and yourself, Minister, could return to in finalising the debate. And given that there are indications that the techniques of this company were used to interfere in the Trump presidential election and the Brexit referendum in the UK, the closing of such potential loopholes is important, and again perhaps this is something that might be addressed when you're wrapping up and indeed at committee stage. There are many welcome provisions in the bill. Section 33, for example, providing for the designation of the data protection officer is very important, and obviously we've been briefed, I think, today again by our own legal team of how the GDPR will impact on us and how the conditions that we have to fulfil in relation to this and in relation to the bill itself. I also welcome Section 83, which sets out provision for dealing with breaches of personal data and the notification of such breaches. Subsection 1, Section 83 states the Controller shall notify the Commission of the breach within 72 hours, and if it's longer than 72 hours, they must include the reason for the delay in notification. However, Section 84 seems to state that data subjects do not always have to be notified of data breaches. Subsection 2, for example, if data has been encrypted and was unintelligible, the Controller is not obliged to inform data subjects. So again, with the massive developments of IT over recent years and media platforms, again, as I think my colleague Deputy Pringle said, we're always chasing to try and catch up with what the latest situation is. And finally, Minister, I don't think many people understood why the government was going to exempt government and public bodies from regulatory fines for breaches of data protection rights. Following, of course, again, the excellent work of our Senate colleagues, there will now be fines up to €1 million for breaches, and of course it's far lower than the €20 million, 4% of global annual turnover, which will be directed against other organisations. And the Data Protection Commissioner, Helen Dixon, has also told your Oireachtas committee last year that the proposed exemption from fines by public bodies was concerning to her and something that we shouldn't have done. So, in conclusion, I will be supporting the bill, and of course I hope that the rights of data subjects, all of us, will be seriously reinforced and respected from now on. Thanks.